Minister John Penrose.
Dame Rosie, this has been, I would say, a difficult debate during the course of this afternoon because it has laid bare some very, very fundamental differences in approach. It has been, I would argue, predominantly a respectful debate where people have held strongly held and highly principled views on opposite sides of some very important and tricky cultural issues, but it has laid bare some very fundamental differences of opinion and divisions within both our society, within this chamber, and I would argue probably in parts of Northern Ireland at the very least. There have been some absolutely barnstorming speeches, Dame Rosie. There have been barnstorming speeches from my very good friend, the Right Honourable Member for Arundel, who was outstanding, and also from the Honourable Gentleman for Rutherglen and Hamilton West, passionately arguing, plus others, of course. I will not embarrass everybody by going through them all, but I mentioned others in the second reading debate, but also some rather quieter but equally respectful and careful comments and arguments from people such as the Honourable Gentleman for Strangford, who gave a very measured and careful exposition about why he feels the way he does and why his constituents feel the way they do, and also Honourable friend from Congleton, who spoke in a similar vein on a similar way. And I think this just illustrates the care with which everybody has had to approach these issues during the course of this afternoon's debate. I'm therefore grateful for all the contributions that everyone's made. It's an important bill and we absolutely need to get it right. That was made clear in the second reading debate yesterday. I'm going to attempt to take the amendments in this group in a sort of roughly sensible order, and we'll be glad to give way where any honourable members wish to probe the government's position any further. But in opening my remarks, I want to make clear our view that of the many amendments before the House today, many, if not most, relate to devolved matters. Those devolved issues should rightly, as has been made, a point that's been made by many people during the course of this afternoon, they should rightly be the responsibility of the Northern Ireland Assembly. Our constitutional settlement for Northern Ireland is based on the fact that Parliament has devolved responsibility for these matters to local politicians. And while Parliament retains its sovereignty in relation to these areas, we must therefore tread extremely carefully. But, Dame Rosie, as has also been mentioned by many people during the course this afternoon, the Northern Ireland Assembly is not sitting at the moment and has not been sitting for more than 2 years. That's a source of huge frustration, not just to those of us here today, but also in Northern Ireland itself and probably in the country at large. And that frustration, Dame Rosie, that frustration is starting to boil over. Patience is wearing thin. People are increasingly unwilling to wait much longer, and the result is the long list of amendments we have before us today, where a simple, straightforward bill, which only seeks originally to change 2 dates, that's all it seeks to do, has been expanded and lengthened in a whole range of areas. Firstly, there are amendments on issues of conscience, same-sex marriage and abortion, which are traditionally free votes in Parliament, and I would just like to take this opportunity to confirm that my party does not intend to break that important principle today. These votes will be up to everyone's individual consciences, and I think I'm right that I've heard that from a number of other parties as well. So,
for the avoidance of any doubt whatsoever, the position is the same on our side.
Minister.
A rare intervention from an opposition whip, and I'm delighted to hear it. I'm sure his benches will also be glad to hear that too. So as I will go on to set out, the government will. So those will be the issues of conscience will be free votes on both sides of the House. As I will also go on to set out, the government is also willing to accept some of the amendments on reporting commitments, where honourable members do not wish to withdraw their amendments. But most of these are asking the UK government to report on devolved matters, as I mentioned before. These are not technically matters for us, and I hope that the House will therefore tread carefully and think carefully about the way it uses those powers today. The other broad category of amendments before the House relates to requirements to debate certain matters, often to debate the reports which are being requested in other amendments, which we will be covering in a minute. Now, the government, we would prefer not to accept these amendments, But we are happy to commit to making an oral statement to accompany the reports, to respond to those reports which are required and may be amended to be expanded under Clause 3 of this bill. And that oral statement, I hope, will provide the House with ample and proper set-piece opportunities to debate the issues raised by those reports as much and for as long as the Speaker sees fit, which I suspect, given prior performance, indicates it could go on for quite some time. I will.
Thank you. I'm most grateful indeed to the Minister for allowing me at this very early stage. But in light of the untimely and shocking death this morning of Sir Anthony Hart, I wonder, would the Minister just give a firm commitment that his government, and the Secretary of State is present in this chamber, will implement at the very earliest opportunity the recommendations made by Sir Anthony after very thoughtful and careful consideration on his part. We are the losers without him. It would be a wonderful testament to him and his legacy if the government would give a firm commitment today to implement at the earliest opportunity his recommendations.
Minister.
If the Honourable Lady will possess her soul in patience, I am going to come to that important point. I wanted to try and take things in the order that they came up, but I will get to it, I promise. And I'm sure that if I don't, she will pull me up to make sure that I do address it. But I will endeavour to make sure that is covered. So I hope that is an acceptable alternative to the idea of an oral statement is an acceptable alternative to appropriating large swathes of parliamentary time to debate individual issues and reports separately. It's probably better to take them as a large and proper oral statement instead. I will start therefore with new clause 1, which is the point about the same-sex marriage regulations. Now, I should start by saying that there are, as we mentioned before, and I started by saying more broadly, there are fiercely held and strongly principled views on both sides of this issue. We've heard them during the course of the debate this afternoon, and whether you are in favour or against same-sex marriage, whether you believe that devolution should trump human rights or human rights should trump devolution, I think that everyone will agree, I hope everyone will agree, that this is significant legislation. A significant proposal, both in terms of its importance and its complexity. It is not something that can be delivered without a careful consideration and analysis of whether or not we're getting it right. Now, personally, on a free vote issue, I appreciate and sympathise with the honourable members trying to achieve here, and I appreciate that many people in Northern Ireland are tired of waiting for their rights to be recognised on an equal footing for their friends, family and neighbours across the rest of the UK. I appreciate, though, that is not a view, as outlined by numerous people, including the Honourable Gentleman from Strangford, which is universally held across Northern Ireland. I will happily give way.
Mr. for giving way. And when he talks about the issue of human rights versus the devolution settlement, would he agree with me that what came across in the debate, and hopefully will be held not just here in GB but in Northern Ireland as well, is that it is the selection, the careful selection and the cherry picking of some issues regarding human rights but not others that causes the frustration?
Well, yes, absolutely, I would accept that there is a great concern that by creating one list of amendments today, that by omission we will leave out some very important things indeed. So, yes, absolutely, and I'm afraid that is something which is inherent in the frustration which I was referring to right at the start of my remarks about the fact that the Northern Ireland Assembly has not been sitting for well more than 2 years now, and I'm afraid that frustration will only grow as that period lengthens. That's why it is so important, and why the original purpose of this bill, as announced by my honourable friend, the Secretary of State, at second reading yesterday, is to do something very simple, which is just to extend a little bit more time in order to give time for the Stormont talks to bear fruit. And while those talks still have breath and life in them, then I hope everybody here will support that opportunity and will wish those talks well. So, as I said, on this free vote issue, while I appreciate and sympathise with what the honourable gentleman is trying to achieve here, I would just issue a note of warning to anybody who is considering voting for this at the same time, and it's a technical note of warning rather than one on the principle, because the principles have been debated extensively during the course of our discussions this afternoon, and because it's a free vote issue, the government itself will not be putting across a principled view one way or another. But the technical point, which I think does need to be made, is that it's just to make sure everybody is aware that based on the way this draft clause is currently drafted, the changes that would need to occur before the first same-sex couple could legally marry in Northern Ireland are probably not achievable, just as a practical matter, by October. There are many policy questions to be worked through which have not yet been properly considered for the Northern Ireland specific context, which may require a different response to England, Wales and Scotland. Matters such as pensions, conversion of civil partnerships, gender recognition. We've heard many of these points raised in various different contributions during the course of this afternoon. Protecting the rights to freedom of religion and expression, and allowing via opt-in, not compelling, religious institutions to be able to engage in and perform same-sex marriage ceremonies. So I would issue that technical warning to any colleagues here who are considering supporting this amendment in principle, whether you agree with the amendment or not. And however you personally balance the competing claims of devolution against broader human rights, bear in mind that this new clause may need substantial further work before it can achieve its intended effect. I will move on now to Amendment 13, in the name of the opposition, about same-sex marriage reporting. This will commit the government to publishing a report on progress made in preparing legislation to make provision for the marriage of same-sex couples in Northern Ireland at the time of publishing the overall progress report under Clause 1 of the bill. And as I mentioned before, we are willing to accept that amendment, and of course it will be afforded a free vote should it come to a vote. If I can now turn to some of the amendments on abortion. I'll start with Amendment 11 and Amendment 9, if I can. We've already mentioned the strongly held views and the fact that these have had attracted a great deal of debate in this House over the last year. I can confirm that the government would be content to accept these amendments 9 and 11 on the basis that we're happy to report back to Parliament on what are important matters about which I know that everybody has a very strong view. This is my point about reporting, and I hope that the honourable lady from Kingston on Hull North, I think North, will be appreciative of our willingness and I hope our goodwill in that area. I will move on from that, given the tightness of time, because I want to make sure I've covered everything else. There are other abortion amendments, notably New Clause 10, the honourable lady from Walthamstow, plus 11 and 12, which are the associated ones about statements and bits and pieces. I think that my remarks on New Clause 10 are very similar to my remarks on New Clause 1. Different topic, same point, which is that regardless of how people may be minded to vote on the underlying principle, I think that there are real and genuine concerns about the technical effectiveness of New Clause 10, and therefore I would issue the same technical note of warning to anybody wishing to vote for it, they having made up their minds on the basic points of principle which have been extensively debated already. I'll quickly give way.
Can I just check with him, though, that despite the technical warnings, which he's probably quite right to issue, the government would honour the result if New Clause 1 and New Clause 10 were to pass? They would facilitate those requirements.
Absolutely. I mean, this is also a free vote issue. So should this pass, it will go into law. It will become part of primary legislation, and therefore, ministers will be bound by it, and government will proceed. But people just should be aware that many of the same concerns that I was raising about New Clause 1 also apply to 10, and therefore there may be issues. I will do one and then the other, and then I will have to make some progress.
Will he give way? New Clause 10 says that the government should implement the full CEDAW recommendations, and the first recommendation of the CEDAW report is to repeal sections 58 and 59 of the Offences Against the Person Act. Does he agree that that repeal would affect all of the UK, including England, as well as Northern Ireland?
Which again, I can go through. I'm not sure I have time, but I can go through some of the other technical concerns about this. But that is only one of the potential issues. So there are broader points which would need to be fixed but the question is whether or not the House is interested in the principle here, I suspect, on a free vote. I will happily give way once more, then I must make progress.
Minister of State for giving way. Isn't it the case with new clause 10 that the way it is drafted is very, very broad and covers all of the recommendations? There are many, many technical issues in those recommendations. There are many policy questions that need to be asked, and it's wholly inappropriate that that happens by regulation, where there is no scrutiny or a process to decide what the policy should be on each and every of those recommendations.
And as I mentioned in my remarks in my response to new clause 1, it is entirely probable that it would not be possible to achieve this by October at all, and it is certainly something which, when we made these changes more broadly for the rest of the UK in previous years, it was done by primary legislation, not through secondary. So the Honourable Lady makes a very, very valid point. And so I wanted to make sure, as people reach principled decisions on an issue of conscience, on a free vote issue, on both sides of the aisle, that people are aware of the technical concerns around that, just so that they are making an informed, principled choice as well. Can I also move on to new clauses 4 and 8? I'm trying to pick up time here, so I'm not running out of time. They would oblige the government to schedule a debate on the issue of progress towards meeting international obligations in relation to the reproductive rights of women, and on the issue of progress made towards implementing marriage for same-sex couples in Northern Ireland. I've already mentioned that the government intends to make an oral statement to accompany the bill, to accompany the report under the bill's clause 3, and I hope that that will mean that people will be comfortable with that, and that therefore the opposition front bench will feel able to withdraw those amendments. I now move on to victims' pensions. That's Amendment 10 and new clause 2. These amendments commit the government to publishing a report on progress towards preparing legislation implementing a pension for those seriously injured in the Troubles, and for this report to be debated in Parliament. Now, this is a very important issue. The government takes it very seriously. And that's why the Secretary of State has already requested updated and comprehensive advice from the Victims Commissioner, which we have recently received. The completion of that advice represents an important step forward in taking forward a pension for victims of the Troubles. The NIO is therefore undertaking detailed work on the next steps based on that advice, with factual input and support from the Northern Ireland Civil Service. We will keep the House fully updated on progress, and will therefore be accepting Amendment 10 to provide a report on those issues. I'll have to give way.
Will the Minister confirm what I understand from his answer to my honourable friend, that on a very narrow bill, which is essentially about setting dates for the Northern Ireland Executive, we are going to change the entire abortion law of the entire United Kingdom?
Minister.
No, Madam Deputy Speaker. I think I can probably reassure him on that. But I would just reaffirm to him that there are real technical concerns about this clause, and that those will have to be fixed. And he's also broadly right on the broader point, which is that a very simple bill that's only supposed to change 2 dates has ended up with a very, very large number of other amendments attached. So he has an underlying point, at least, which is broader, I think, as well. I really must make a little bit. I'll go once more, and then I really must make progress, because I do want to get to.
Minor CEDAW committee report says that the committee recommends repeal of sections 58 and 59 of the Offences Against the Person Act 1861. Will that repeal affect the entirety of the UK, not just Northern Ireland? That is the question.
As I understand it, then if we repealed it, then yes, it would. However, I think that the point that's been made elsewhere is that that isn't necessarily the route you have to go down, because those clauses have been dealt with in different ways for the rest of the UK already. I don't want to revisit the substance of this, particularly since it's been debated extensively already. So with everyone's permission, I would like to move on, if I could, it being tremendously important. And I'd like to move on to the historic victims of institutional abuse. And can I just start by expressing my sincere sadness at the death of Sir Anthony Hart. He was a dedicated public servant and highly respected High Court judge, and as chair of the Historical Abuse Inquiry in Northern Ireland, he provided a comprehensive set of recommendations for redress to be delivered to victims and survivors of historical institutional abuse. And I'm sure our thoughts and condolences go to his family and to his friends after his unexpected and very recent demise. I also understand the frustration of victims and survivors of this terrible abuse. We absolutely must do everything we can to ensure that the victims and survivors get the redress that they deserve. Following recommendations by the Northern Ireland parties, the Executive Office is working with the Office of Legislative Counsel to redraft the legislation required to establish the redress scheme. The opposition proposes, I think, that Clause 3 includes a requirement to publish by 11th of September a report on progress made in implementing the Hart Report, including a compensation scheme under a redress board. And given the importance of the matter, the Government are happy to accept this amendment and will report back to Parliament on this vital matter. Madam Deputy Speaker, this collection of amendments has been something which I think many people have been concerned about its size, about its length, and indeed about its composition and the set of priorities which it otherwise seems to reveal. And I would just say on a broader point that the concerns, I think, which were uncovered in the second reading debate yesterday have become ever more clear in detail during the course of our debate and discussions here today. The concerns are simply that because people are getting worried about the failure of the Northern Ireland Executive and the Stormont Assembly to sit, there is a danger that the credibility of that Assembly, and with it the credibility of the Northern Ireland Democratic Settlement, will begin to be undermined, that it will begin to be eroded, and with that we are starting down potentially an extremely dangerous slope where the credibility of democracy and of peaceful resolution of disagreements in a historically bitterly divided society, that democratic solutions cease to be the obvious answer. And that is something which we must avoid at all costs. It is an essential outcome, an essential goal which we must never lose sight of. I will briefly give way and then
I'd like to thank the Minister for giving way. Many members have come into the House who haven't had a chance to listen to the longer debate. I wonder if he could just clarify again which of the amendments that are related to ongoing reporting requests that the Government accepts.
Minister.
Madam Deputy Speaker, I probably better not try your patience by going through them all. We have accepted a fairly large number of the reporting requirements, and we are happy to report back to Government, to this House on the basis of that. With my honourable friend's indulgence, I will perhaps go through the individual amendment numbers with her separately afterwards, and with that I will draw my remarks to a close.